Hi, my name is Gulfamili Raza and my student ID is 23091010. I'm here to record the video presentation for my module data protection as a CW-1. Let's start with the introduction. Introduction to generative AI and data protection risks. Generative AI models that have been recently developed by companies like X, which is also named as Twitter, and Meta require massive data sets for training. Such data sets contain personal information which is retrieved from users' open posts. Although AI brings positive changes, it also possesses severe privacy threats, especially on the aspects of lawfulness and transparency in compliance with GDPR. GDPR is based on lawfulness, fairness, and transparency as per Article 5, Subclause 1A. But large scale AI training violates these fundamental principles. X and Meta's efforts to gather personal data for AI training have attracted intervention from the Irish Data Protection Commission and the UK Information Commissioner's Office due to issues with user consent, inadequate notice, and the absence of clear legal basis for data processing. This presentation aims to critically discuss the legal measures and procedures that need to be put in place to meet GDPR standards. More specifically, it examines the legal permissibility of AI training, the issues of transparency, and ways to minimize the privacy risk with reference to the relevant legal provisions and enforcement cases. Let's move to the second slide, which is lawfulness of AI training under GDPR. In order for any processing to be legal under GDPR, it must be based on one of the legal bases as set out in Article 6 of GDPR. The application of user consent, which is under Article 6, Subclause 1A, is not feasible in the case of training artificial intelligence because of the large volume of data and impossibility of seeking permission from all the users. Legitimate interest, Article 6, Subclause 1F is a frequently used justification by AI firms stating that data processing is required for advancement in technology and innovation. However, this basis is not absolute, and the truth of this statement can be seen when considering the following points: demonstrate a legitimate interest in AI training, prove necessity, and show that individual rights do not override corporate interest. This legal basis is highly contentious because AI training entails scrapping large amounts of personal data with no obvious ways to opt out. The CGAU's rulings in cases such as Google Spain SL versus AEPD 2014 thus acknowledge that privacy rights have to be balanced with corporate benefits. In addition to this, the inability to fine tune the input data increase the risk of abuse and overinterpretation of the training data by the artificial intelligence algorithm. The next slide is the slide number 3, which is transparency challenges. Transparency challenges and GDPR compliance. Compliance of GDPR. Transparency is another of the GDPR articles 12 and 14 that state that the organization must provide clear, understandable, and easily accessible information on the process of personal data. However, the AI models themselves are not transparent, especially when it comes to the process of data collection, storage, and use. Regarding the case of Meta and the use of Facebook and the Instagram data, the ICO intervention led to the change of company's behavior. Now it needs to provide users with better notification and objection before continuing training the AI. This shows that regulatory pressure can bring about changes in the level of transparency, but such changes are on the surface rather than at the institutional level. Article 22 GDPR adds another layer of complexity where individuals have the right not to be subjected to decisions based solely on automated processing where such decisions produce legal effects. AI models work in such a manner that it is hard to know whether one's data is being used in AI decision making. Another aspect of transparency that is affected by AI is that the models do not come with sufficient explainability mechanisms, thereby leading to accountability. Also, the training data for AI models are in many times scrapped from social media platform, which is not transparent to the users. This is not contrast with Article 14 GDPR that provided for situation wherein the data subjects are to be informed when data is collected indirectly. In practice, however, this obligation is hardly ever complied with, which means that the users do not know their data is used in AI model training. Despite these limitations, regulatory authorities are now encouraging algorithmic impact assessment (AIA), a relatively new concept that may enhance the use of AI by making developers analyze the risk associated with the data meshing, the legalities of processing, and the protection of data before deploying an AI model. Now moving to the next slide, which is about the key safeguards against privacy risks. What are the privacy risks and what safeguards we have? Protecting privacy in the context of AI training requires both technical and legal measures. There are various measures that can be taken in order to address the risks that are inherent in legal scale data processing and to meet the GDPR requirement. Differential privacy and federated learning. These technologies decrease the likelihood of direct exposure of personal data by adding statistical noise to the data. Explicit user opt-ins, strengthening user controls mechanism aligns with GDPR consent framework, but poses feasibility issues in AI training with billions of data points collected. Required explicit permission would significantly disrupt AI model development. Data protection impact assessment under Article 35 GDPR. DPIAs are compulsory for high risk processing, yet they are often overlooked or inadvertently conducted by AI firms. The enforcement of regulations should increase the compliance level by insisting on a risk assessment to be performed before the training of the AI model begins. Proactive regulation. As seen in the DPC and ICO cases, proactive detection is zruri. This essay concludes that without proper measures in place, AI training will remain a threat to the data subjects, and there is a need for reforms in governance of AI incorporation and the enforcement of the laws. Let's move to the concluding and the second last slide, which is mitigating privacy risk in large scale AI training. Thus, to address the privacy concerns, both the developers of AI and the regulators need to employ legal, technological, and policy based measures. Several key strategies include anonymization and synthetic data. By using synthetic data, models can be trained without unique identifiers, but re identification is still possible when combined with other datasets. Enforcing the right to object under Article 21 GDPR. Users need to be able to object to data processing, but objections are often dismissed due to the size of the data processed by AI systems. Instead, regulators need to put in place through which rights can be enforced in the AI related scenarios. Judicial resistance to mass data processing. Courts across Europe have been raising concerns against mass data processing, as evident in SCANS 2 and CNIL enforcement actions against the unlawful AI data collection. Such decisions imply increasingly bigger risk to AI training practices, which means that firms will have to operate under more stringent legal requirements. Strict penalties under Article 83 GDPR, and these articles give penalties to the penalty to the objections. Now moving to the last slide, which is conclusion: the future of GDPR and AI regulation. The future of GDPR compliance in AI training hinges on regulatory enforcement, technological adoption, and legislative reform. Thus, while companies like X and Meta adopt their behavior as the result of pressure, their actions are not preventive but responsive, which proves that companies need to have the more extensive compliance responsibilities. New AI specific legislation, including EU AI Act, will build on GDPR by setting higher compliance standards for high risk AI system. However, legal ambiguity remains, especially in the areas of AI generated content, responsibility, and data production. In the end, the problem is to strike the right proportion between the development of artificial intelligence and the human rights. Thank you very much.